いい楽しみだよな。
Good evening, all. We will wait for a couple more minutes before we'll start the program. Very good evening to all. Before we commence the program, I request the audience to mute yourself till you have some questions, and question answer session will happen at the end of the program, at the end of the lecture. So you can mute yourself and request you to keep your videos on so that we'll also be able to see your lovely faces. We are starting the program now. Very good evening to all of you. My name is Geeta Sridhar. On behalf of Vice and Worth Advocates and Consultants, I'm delighted to welcome you all to the Edu series. We are happy that you could join us in the evening, this evening, despite your busy schedule and a nearly end of week. Edu series is aimed at enabling corporate executives and practitioners to apprise themselves of the evolving changes in the business and economic laws. It is being held every month, covering various topics and legislations issues that would impact the business and practice. The topic for today, as you are aware, is mediation in India, transforming dispute resolution. Mediation is undergoing a transformation shift and shifting itself from supplementary approach to central approach in the dispute resolution. The Mediation Act 2023 aims to establish mediation as a primary method for resolving civil and commercial disputes, reducing reliance on traditional litigation, and fostering a more amicable and efficient dispute resolution ecosystem. This would not only resolve disputes timely, but also reduce the judiciary burden. By promoting mediation as a primary method, the aim is to create a culture of negotiation, collaboration, and amicable settlements, ultimately transforming the landscape of dispute resolution. The success of this transformation will depend on effective implementation, awareness campaigns, and the active participation of all the stakeholders. Over to Ms. Pallavi Bhaskaran to introduce the speaker for today, Advocate Surya Narayanan.
Thank you, ma'am. Good evening, everybody. Welcome to today's Vice and Worth Edu series, which is on the topic Mediation in India Transforming Dispute Resolution. Today, I have the immense pleasure of welcoming Advocate G. Satyanarayan, sir. We welcome you, sir. He's a renowned advocate who is practicing at Madras High Court and Supreme Court in the area of civil, criminal, and corporate matters.
Pallavi, are you there?
Yes, yes, ma'am. I'm there, ma'am. Just a clarification. Am I audible?
You're audible. Go ahead. Go ahead.
Okay. Sorry for the inconvenience. Um, he's a renowned advocate who is practicing at Madras High Court and Supreme Court in areas of civil, criminal, and corporate matters. He has completed his LLM in international business and finance law with super honors from USA. He has over decades of advocacy practice and also an international accredited arbitrator and mediator. He is also an associate member of Chartered Institute of Arbitrator, London. He has completed civil and commercial mediation, master class at mediation with ADR ODR London. He has completed mediation training. He is conducted by Honorable Supreme Court of India. He has been judged in various international moot competition in mediation and arbitration on digital currency and crypto assets. He has been awarded the Leg Falcon Global Award for the best commercial lawyer at Singapore in the year 2022. His deep understanding on alternative dispute resolution makes him the perfect person to guide us to today's topic, which is mediation in India transforming dispute resolution. Today, he will be sharing his profound knowledge and his insight on today's topic. So, please join me in giving a warm welcome to Mr. Satyanarayan, sir. Mr. Suryanarayan, sir, the floor is yours, sir.
Thank you. Good evening, all. I thank the organizers for this wonderful evening. Mediation is a fast-growing topic. Not only topic, it is a alternate dispute resolution that is fast-growing in India. As far as the world internationally, it is best used as the alternate to court dispute. Mediation evolves from the process of negotiation by a third party for settlement of dispute outside the court without a trial. So, when it comes to mediation, we always take it from the international scenario where negotiation is considered to be the best format for dispute resolution between nations, for stopping a war or for settling a trade dispute. Mediation evolves from the process of negotiation, and mediation has been very successful for the purpose of dispute resolution as alternate to court resolution. A third party who has a charisma, influence, language, as well as the knowledge over the subject is normally appointed as mediator. The person who mediates should make the process of mediation is voluntary and party-centric. Unless the parties know that it is voluntary and party-centric, they will not be in a position to concentrate, undergo the decision-making process in a fruitful manner. The mediator's duty is to guide the parties in a paced manner through the process of settlement. Since mediator is neutral and is not worried about the outcome of the dispute, his only activity is making the party to talk, to make them understand their needs, their requirement, their wants. Then what will happen is to make them understand the real need for which they are fighting. Once the real need is understood, it is very easy for the mediator to work for the outcome. The process of mediation, therefore, goes through few processes where we would say there will be joint session, there will be private session called caucus. And through those process, the mediator tries to settle the dispute. In India, Section 81 of the Arbitration and Conciliation Act also has a provision which will give confidence on the parties to disclose various events, documents by which a settlement could be arrived at, as those details or documents cannot be used for the court of law when mediation fails. Therefore, the introduction of Section 81 as a means to bring about party settlement has also helped the process of mediation in a better way for the mediators to convince the parties that they can have the confidence in the process. As far as India is concerned, 90% of the mediation happens only through court annex mediation. Court annex mediation is a process where the court always to limit the time that is spent on a dispute resolution sends the party for mediation. This process of sending the dispute for mediation is called court annex mediation. When the court annex mediation is sent to a mediation center, the mediation center normally appoints a mediator. The duty of the mediator thereafter is to introduce himself and to disclose 10-point opening statement, which will inform the parties about the conduct of mediation process, confidentiality, the process by which the respect to each others are maintained, the process by which by each and every event, the mediator will help and also that he is neutral and he has no interest in the dispute that is involved between the parties. Thereafter, the mediator will ask the parties to make their opening statement, whereby he'll ask the parties to introduce themselves and as to how they should be addressed. Then we'll ask the parties to make a opening statement of their case. Once an opening statement of a case is made by the parties, that opening statement will also be confirmed by the mediator to show that the mediator has understood the gist of the opening statement made by the parties. Then the mediator proceeds for a joint session. for the purpose of mediation, unless the mediator has the knowledge of the dispute as well as the modus of the dispute that is involved between the parties, the mediator will not be in a position to help the parties to go through the process of mediation. Therefore, the process of opening statement and making the parties disclose the details of the dispute at the first session will be the primary object of a mediator. Once the opening statement and the understanding of the dispute has come to a confirmation stage, then the first joint session to know about the veracity of the statements made by the parties will be done by the mediator. Confirmation of statement alone will be made not to test the veracity, is because mediation itself is to impute confidence in the parties. If we are to confront the parties about the truth or the nature of the statement made by the parties will lose the confidence in the mediator. Therefore, the mediator is not supposed to question the party as to the truthness of the statement made. He is not supposed to acknowledge by saying, okay, I understand, I accept. All these objective statements should be avoided by a mediator while conducting the process of mediation. The mediator also has to inform the party that whatever he notes down is only for the purpose of his understanding, and that will not be used by the mediator, or it cannot be used by the parties, or it will not go to the court. As even the recording, day-to-day recording made by the mediator during the mediation session or after the mediation session will not be sent to court. The court also cannot seek the mediator why the mediation failed, except that the mediator will inform the court that mediation has failed or settlement has arrived. Except that even the court cannot ask the mediator what transpired in mediation. That is why this process has gained prominence among the parties as an alternative method of settling the dispute. In court process, normally the parties will go with pleadings, go for evidence. It will take a quite number of years for the purpose of settlement. In mediation, the process during the court annex mediation is curtailed to 90 days. First 60 days, the mediator should try to settle the dispute. If it does not happen, he can give a report that the parties are in the process of settlement, and by which process he can seek an extension of 30 days. 90th day, if the mediation happens or not, he has to send it to the court. If the parties are willing to settle, for extension. If not, the court will again take the matter for the purpose of deciding the dispute on merits. As far as the joint session is concerned, the process by which the mediator helps the parties to understand the gap that has occurred in their understanding. What will happen is the mediator will question each one of them as to how he decides, what is the nature of work, what is his culture, what is the nature of household he has. So, by that, both parties can understand each other's understanding and perspective for them to really see how the other party can understand their interest or what is their requirement. This process by which the mediator helps the people to decide what they should tell the mediator or how they should tell the mediator should will also be guided by the parties. The mediator helps the parties to tell him all the informations that is required for the purpose of settlement of the dispute during the joint session. In that process, he can also put forth questions to the parties for understanding the nature of dispute, the wants of the parties, and also the needs of the parties, as well as the difference, why the differences arise between the parties. Normally, the mediator avoids putting the party in any surprise by his conduct. Therefore, through the process of mediation, the main aspect is that the mediator should be a better player. Then alone the process of mediation can go on quite well as help the party to understand the process of mediation. And only after few joint sessions, the parties will be in a position to open up after gaining the confidence that the mediator is capable and he has understood them well. They will start opening up and tell the mediator about their requirements, their wants, their needs, how the gap arose, what would be the best way for them, and why they have come to court. This process of negotiation during the joint session always has a bearing is because once the joint session goes on very well and the parties have gained confidence, the mediator can take the parties to private session, which is also called caucus. In the private session, the mediator will help the parties to tell him what cannot be told during joint sessions. Unless the party has gained the confidence that is required in the mediator to disclose the details as to his expectations or the way that he has expected and that there is a failure or how he was affected, all these things, if he could not disclose in joint session, if he has gained confidence in the mediator, in the private session, the parties will divulge. But before the private session is commenced, the mediator also tells the parties that whatever is disclosed to him will not be disclosed or put to use with the other party directly. This confidentiality process helps the party to disclose. What will happen if I am to disclose what is divulged by the other party? The entire process of mediation is lost. Therefore, what should be done is that in private session, the party should be informed unless the party authorizes the mediator to disclose the facts or what is stated by them as confidential things or their decision to be in or the result that is required by the party. The mediator is not supposed to inform to the other party. In this process, normally, since ours is a court annex mediation, we don't indulge in the process of putting the parties to the process whereby we make them to say that this litigation will not be admitted by the court, this litigation will not be decided by the court in their favor, this litigation will cost you this much, you will be paying so much of cost, and these are all the citations against you. this process is not permitted and is not used in India, but in other countries, since mediation also happens outside court by private agreement between the parties, the mediator will tell them the cost involved in the litigation, the outcome of litigation for the to pressurize the party to come for a settlement. By the process, through this process, what will the mediator do is there are three concepts of mediation which will be applied, which is called Vatna, Bhatna, and Zopa. Vatna is what is the alternative to court dispute? What is the best possible result to court dispute? What is the benefit of deciding in mediation is Bhatna. Zopa is arriving at the scope of settlement, how the dispute can be settled, process of dispute can be settled, zone of agreement between the parties is Zopa. So, during the process of joint as well as private session, the mediator will take the parties through the process whereby they understand how they have come through the process of litigation, how that litigation will end for them, or what is the probability of getting a result. And if a decision is not made by a third party who is a judge, and if I am to decide my own case because I have come to the court for the purpose of my benefit and for the purpose of my interest, if I am deciding, and that decision will definitely will have a bearing in my future. Say, if it is only a commercial contract, if I am going to settle today with this person who is already on the mediation table may even get a better uh, opinion about the person who is settling the matter in mediation, and he may also get more future contract. Through the process of mediation, the mediator helps them in understanding how in this process the parties can settle through to gain beneficial ending of the litigation. Consideration for mediation, and that is why mediation is supposed to be the best alternative for litigation, and the courts are today putting this as a best alternate for dispute resolution. Why mediation? Is because again there are other processes called arbitration and negotiation. Arbitration, again, a third party sits and decides a matter on merits. A decision making by the third party is what is not required, and that is why this process of mediation itself is initiated. If we are to go for a third party decision making, then the arbitration, one has to decide it would be better for them to go to court or for arbitration. If they do not want both, they can sit down, settle in mediation, is because in this process, the party decides what is required for the present and for the future. He can also see that what has happened to him in the past is also redressed. That way, the interest protection process is the success of mediation. This process of success in mediation is the highlight for the party to understand the process and decide. He does not decide this issue alone. He decides how to settle the past dispute, the present, and the future. Therefore, this process has got more prominence is because if you go to court dispute, only what has happened in the past gets settled. What is there in the present and future may follow what is decided in court, but you cannot say with certainty that will have a following. So, in this process of mediation, the party can always seek a settlement by which he settles the past, present, future of the dispute or his needs, wants, and requirements with the party who is already there. And normally, except in property dispute, commercial disputes, they'll be seeing each other's face on a day-to-day basis. So, by the process of mediation, the parties are in a position to, or the mediator helps the parties to understand that they can decide what is their best interest, how they should put forward their best interest, what should be the outcome of the process of settlement, how they want a settlement, what is the settlement that is required for the past, present, and future. When both the parties had agreed for the outcome as settlement, then the goes for settlement agreement. As far as a settlement agreement is concerned, in a court annex mediation, normally the mediator will ask the parties or their advocates to do the settlement agreement. But there is also a draft of model of settlement agreement that would be available with the mediation center. Many cases, the mediator helps the parties to do the mediation agreement. But outside the court annex mediation, it would be better the mediator informs the party to get the mediation agreement drafted by themselves or by their lawyers. Is because it is the parties who knows the reaction of the other person when a particular word is used or the usage of the trade is used or the manner in which the act, omission or commission is agreed to be committed in a settlement agreement. Therefore, the mediator shall always tell the parties to draft their own settlement agreement. In the court annex mediation, the mediator shall look into the settlement agreement to see whether the agreement is legally valid, enforceable, and it can be passed as a decree by a court of law. Because it is not only where the parties will enter into settlement agreement and by which the mediation will end. As far as the court annex mediation is concerned, once a settlement agreement is reached, it will be sent to the court to pass it as a decree. Therefore, the mediator's foremost duty when he receives the settlement agreement is that he should see that the agreement is enforceable in a court of law. It can be passed as a decree, and the agreement is not one-sided, or that it is not illegal, even if it is. See, one-sided, normally it is between the parties to agree what they want. It is not for the mediator to say it is one-sided, therefore you don't agree. But what the mediator has to see is whether the agreement is not illegal. Only to that extent he can see whether that process of settlement has validly been entered. Over and above that, he cannot test whether one party has gained, one party has lost. All those things are not within his realm. For him to comment on the settlement agreement and tell the parties, please do not agree. That is not within the realm of a mediator. It is for the parties to agree what is required. Then, this process of mediation being an interactory session, normally the mediator will help the parties to talk with respect. Tell the parties that if a person is speaking, please do not disturb him or do not disturb the process of mediation. We will give you the opportunity as is given to the one party. The next party will also get the same opportunity as is required. The mediator will also tell the parties to see that we will give you enough time for disclosing or for the purpose of satisfying the party that whatever is the time given to one party will be given to the other party so that he gains confidence in the mediator. Then this process of settlement agreement is recorded in the note sheet of the mediator and it will be sent to the court to pass an order as per the mediation agreement. If the parties are not willing to mediate in the first instance itself, if the parties do not give a consent, the mediator has to send the mediation file to the court. Where after few mediation sessions, the parties are not in a position to arrive at a mediation settlement also, the mediator has to send the file to the court for the purpose of passing orders on merits. Only in case of the agreement being reached by the parties, the mediator will send a report along with the settlement agreement saying that the parties have arrived at the settlement for the court to pass a decree. The court normally passes the settlement agreement as a decree, and at that process, normally they don't test unless otherwise the court sees that it is illegal or such an order cannot be passed. As mediator has already done those process, the court need not go through this process if the mediator has properly done its duty. Next is private mediation under the Commercial Act. Today, by introduction of 12A under the Commercial Codes Act, pre-mediation has been made compulsory in the commercial dispute. By this process, it is felt that before the party comes to the court, they can test themselves to mediate. This helps the party to settle the dispute even before they can pay a court fee or they can go through the ordeal process of finalizing their pleadings or getting ready with the documents. Because in commercial dispute, unless otherwise you are so certain about your pleadings or about the documents, a party cannot initiate the process of commercial dispute. Is because it is a summary process by which the court will ask you to, after the pleadings, the court will ask you to file a affidavit of admission and denial, and with that itself the court can pass a decree under the commercial dispute. Therefore, this process of pre-mediation has almost brought the commercial litigation to a certain extent a better remedy before they come to court. By this process itself, we see almost 50% of the commercial disputes get resolved in the process of mediation. This process of pre-mediation is a welcome move is because in all these cases, though 90% of the pre-mediation goes to state or district legal services authority, there also the mediators are trained very well by the Supreme Court, and they have gone through all the process structures of mediation. The training is very rigorous for these mediators to help the parties to go through the process. Today, there is also a process whereby they ask the mediators to go for training again and again after a few years to hone their skills. By this process, the court sees that the mediators are trained so very well that they help the parties to arrive at a settlement. In commercial litigation, the interest is money or the contract or the process of fulfilling their commercial needs. Therefore, the mediation process before a litigation is always a welcome move because the parties can save their time by sitting in mediation, deciding the dispute. Because as far as a commercial man is concerned, he will always be happy if he decides what is his best interest. And if a third party does not intervene in his dispute, that will be his best interest for a commercial man. Therefore, for those of people who wanted to really see their interest alone, or they see that this process will help them to settle, the Act has brought in a mode by which a pre-mediation process is introduced. There are also certain instances where we can file an application saying that we have urgency and we need not go. But where even after the filing and an interim order is granted, it is always for the court to send a thing, commercial litigation for mediation and for the parties to work out the remedy through their own process of settling a dispute. This process of mediation is successful is because, see, we have seen a long pending dispute of Ram Janmabhoomi was decided by mediation. That is the best example that a person can give for the process of mediation and negotiation that has happened in India. As far as other things also we can say, but every day, if you see today, it is almost taken as a process of like a process of festival, is because the court has seen that filing number of cases, the court is not in a position to decide. Therefore, if the parties can arrive at a settlement through a mediation, which is only a process of 90 days, and the number of disputes can come down, the court will happily say, yes, you are welcome. And by this process, what will happen is if you are paid the court fee, previously, if you are paid a court fee and you are settling the dispute outside, you will be entitled 50% before the trial has commenced. Trial has commenced means before an issue is framed. Today, whether the trial is commenced, whatever has happened, till a decree is passed, if you go for mediation, you are entitled to full refund under the Tamil Nadu Court Fees Act. This also helps the parties to say, I'll get some more benefit is because the court fee that I paid for the purpose of deciding a dispute also come back to me by this process. Therefore, this process of mediation is really transforming as and is the best alternate to the court dispute. By this, I'll end my session. Thank you for the wonderful opportunity and this evening.
Thank you, Mr. Surendran, sir. And that was really, an insight into the mediation process. If you have any questions, you can ask. The floor is now open for questions. At what stage mediation, sir? I have a question for you. At what stage does the mediation is to take place? At the beginning, or at the or in the
Any time if the parties go and
so there's
request the
exactly
court.
no timing. So long as you have
No
the
timing.
intention to mediate, and
Yes.
you can. Okay.
Only in case of commercial dispute, the Commercial Courts Act has a compulsion that you will go to mediation, come back to court. As far as other disputes are concerned, at any stage, the party can say, even in arbitration, the court can say that I'm willing to settle the dispute through mediation. The arbitrator has to refer for mediation.
Thank you, sir.
One thing is that if the arbitrator himself acts as a mediator, thereafter he cannot sit as arbitrator.
Any other questions, please? So how do we take this? That everybody got clarified, or it did not reach you at all?
Madam, one question, madam.
Yes, please.
Madam,
Yes, sir.
madam, one question. See, what we understand is just like IBBI, government is planning to introduce ACI, Arbitration Council of India, or whatever name, like with similar common institution, and maybe they may be having a similar agency like IBBI. Is it correct, sir?
For mediation, either you will have to have a agreement between the parties to go for mediation, or before court dispute in Commercial Courts Act, you will have to go for mediation.
Okay, okay.
Or in the court dispute, you will be sent to mediation. Therefore, in all other cases where in the institutions, if they have the process of mediation, the parties has to go through the process of mediation in the manner that is provided to under the rules or under the set of act that is provided.
Okay.
The question for Mr. Kumar is that, is there going to be a regulatory agency kind of a thing, like for IBC we have IBBI to regulate the process?
As far as the mediation, commercial courts mediation is concerned, there is already rules. This process of mediation is overseen by the judges in a court annex mediation. Therefore, if this process is not happening or the parties have a complaint about the mediator will be changed. They can have another mediator for deciding the dispute.
So because in India, it is only court
news item. See, Company Secretary Institute issued one information or notification, whatever it is. In case of any mediation, please refer to our ICSI Mediation Center at Gurgaon, like that. Is that allowed, sir?
Yes, allowed. It is allowed. It is today allowed.
Okay, got it. Thank you, sir.
Any other questions?
The Ravi Chandran muted. I do not know whether he wants to.
Pavitra, can you do the closing remarks? Yes, Pavitra?
Yes, sir. Good evening to everyone. It's my privilege to propose a vote of thanks for today's knowledge sharing occasion. First and foremost, I would like to express my deepest gratitude to our esteemed speaker, Mr. Suryanarayanan sir, for making time to share his deep insight in the field of mediation. Thank you, sir. Thanks for sharing your knowledge to all of us. And my heartfelt thanks to Heartfelt thanks to our beloved senior Satyanarayan sir for envisioning and rolling out this education series. My sincere thanks to Ms. Geeta Sridhar ma'am for bringing today's session into action and to moderate this session. Thank you, ma'am. And thanks for the entire team and all wonderful audience who are here today with us. Last but not the least, our eternal gratitude to the Almighty, without whose grace this occasion couldn't have been successful. Thanks, everyone.
Thank you all.